if you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. So
Okay.
I would that you do the following things.
This case ultimately became a textbook example of structured accountability. The defendant pleaded no contest to a serious second-degree felony involving methamphetamine. The court accepted the plea, found sufficient evidence, and imposed a 10-year suspended prison sentence, probated for 10 years. That means one violation could activate the full prison term. Judge Boyd layered the sentence with strict conditions: weekly random drug testing, 200 hours of community service, parenting classes, no contact with certain individuals, employment restrictions, and mandatory reporting. The judge also directly confronted the drug use, refusing to allow minimization, forcing acknowledgement, and ordering treatment. This wasn't blind punishment. It was conditional mercy. A second chance, but tightly controlled. So now I want to hear from you. Was this the right balance between accountability and rehabilitation? Or should prison time have been immediate? If you found this case as intense and revealing as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Well, if you are going to stay, then it's very important if you haven't, you're eligible for a recalculation, but everybody here would like to have a nice apartment for $262 a month. And there's a waiting list of people that would like to have your apartment. So share this with DHS and go talk to your manager, but you're in a tough spot. You're close to being evicted. All right, do you have any questions?
No.
Meg, do you see any benefit in speaking with her?
Judge, I'm always happy to speak with folks, but so it's up to her.
Do you wish to speak to the attorney from legal aid?
No.
All right, you're good to go, but you're in a tough spot.
Thank you, Judge. Thank you,
Thank you, Luke. Luke, you can have this and go get your copy. I'll go take care of your other matters. All right, I have the former draft choice known as Jay Felt waiting in the waiting room. Mr. Fleeman.
Yes, sir.
You and Miss Olch had a chance to talk. We've continued the matter to February 13th at 11:30.
Oh, so it was 11:30 because she and I wondered, were you saying 11:30 or 1?
11:30. Yes, 11:30.
Okay. Well, and I'm going to be sending her a conditional dismissal anyway, so I think we'll be fine. But yes, I'm glad you clarified that for me. And I think she is still in the breakout room, Judge.
All right, Miss Ellsworth, you've got your hand up, but I can't hear you.
How about now?
Miss Ellsworth? No.
Yes. Can I speak to Meg in a breakout room, please, before my case?
Yeah, we'll call the case. And Miss Ulch, you're good to go.
Okay. Thank you, Judge.
So is Mr. Flynn. All right. Miss Ellsworth, will you join us? All right. Next matter is Three Rivers. What's it called? Three Rivers Village versus Brianna Ellsworth. Let me make my notes. Once again, Meg Bauer is here. Sarah Reed is here. The manager for Three Rivers Village is here, Pamela. All right, let's recap where we were last week. We were here on January the 30th. We found, sure what we found. Rent of 378 times 3, 1,134 through January. Utilities of 428.43. They had a very high late fee of $85 a month. That's going to have to be adjusted. Then there was a carryover, and I don't exactly remember what our numbers were, 1,389. Meg wasn't here last week. I think she was coming. And I gave Miss Ellsworth the number of legal aid. So Miss Reed, let's establish what we believe the current arrearage is. And then I can always put her in a breakout room with Ms. Bauer.
Okay, thank you, Your Honor. If I remove the overage on the late fees for the 3 months of November, December, and January, 35 times 3 months, that would be removing $105 from her ledger. So that would leave us at about 3,000.
All right. So we also have another month. We're now into February. So How much is the rent?
The rent for February is 378. Do you want a total?
All right. So we have 378 times 4 months.
Mhm.
Is 1,512. Late fees of 4 months times 50 is $200. Utilities of 428.43. Is that still accurate?
I've got, that's the only calculation I didn't come up with.
All right, now let's talk about court costs. We got $68 filing fee, $39.48 service fee, and $75 attorney fee. So let me add that up. 1720. Oops. 1712 plus 428.43 is 2,140.43. If we add our costs of 68 plus 39.48 plus $75 statutory attorney fee, we get 182.48.
The total I have for the water and sewer for the 4 months of November through February is $620.41.
Great, thanks. Now that I've made this whole calculation, I get to change it all. All right. Rent is 1,512. Late fees are $200, 4 months at $50 a month. What's the utility figure now?
The total is $620.41.
And what utilities are those?
Water and sewer.
It's expensive in Three Rivers. All right, let's add that up.
There's also the pet rent that we discussed at the
tell me
last.
if you're going to throw in any more numbers here.
All right. So there's pet rent that we discussed last week of $10 per month times 4, which is 40.
All right.
And then the repayment plan that Ms. Ellsworth signed in July of last year. And when we had the hearing in October of last year, you requested that we send you a copy of that for that hearing. So that's $100 per month times 4.
All right. Let's try again. $1,512 plus 200 plus 620.41 plus 40 pet fee plus $400 get a little punchy. is $2,772.41 through February. Now we got $180.48 in court costs. Gives us $2,952.88. All right, that's what they contend you owe, Miss Ellsworth. This is our second hearing. We did have a case last year where there was some arrearage and then there was a repayment plan. Apparently hasn't worked out. Have you, I don't remember if I asked you, did you ask for any emergency help?
I sent all the information over to Neighborhood Inc. and I'm still just waiting for a reply back. They wanted me to email everything.
Oh, so you're not engaged with Neighborhood Inc. right now?
She told me, I talked to her on the phone. She told me to email her the eviction paper and pay stubs, and that's what I did. And I'm just waiting for a reply back.
All right, well, we'll give you that here in a minute. All right, you wish to speak to Miss Bauer?
Yes, Your Honor.
All right, let me put you in a breakout room. I'm going to remove Ms. Ulsh. She's done. All right, Brianna Ellsworth, room 1. Meg Bauer, room 1. All right, you both join. And Miss Reed and Miss Pamela, if you'd stay with me. All right, Mr. Felt is here with us. Last Friday, we were discussing the promise of the Michigan State basketball game. That promise for Spartan fans, it wasn't so good. If you're a Wolverine fan, I guess you probably liked it just fine. Anyway, Mr. Felt, Mr. DeWitt is here with us today. Mr. DeWitt, can you hear me?
Yes, sir, Your Honor.
All right. We learned last week that you were in the hospital, and so we adjourned the matter until today. So for you, this is actually your first hearing.
Yeah, my dad died in November, Your Honor, and they served me eviction papers 2 weeks after my dad died. And I've been stuck out in the cold at sub-zero temperatures with no bathroom or toilet or heat. And
well, she claims you're living in an unheated modular building on the property and the city won't let you do that. But first of all, let me tell you what your rights are as a tenant. You have the right to hire a lawyer. If you cannot pay for one, legal aid attorney may be able to assist you, or you could seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must make it at your first court appearance, which is today, or file a written demand within 5 days and pay the $50 jury demand fee unless the judge waives the fee for an inability to pay it. If your landlord...
Let's pause right here. The judge has just calculated nearly $3,000 owed, including rent, utilities, pet fees, repayment plan arrears, and court costs. This is no small amount, especially considering no rent has been paid since October. And here's what's critical. When courts look at non-payment cases, consistency matters. Missing 1 month is one thing. Missing 4 consecutive months is another. The landlord already attempted a repayment agreement last fall, and that agreement collapsed. At this point, the judge is balancing two realities: a tenant asking for more time and a property owner who has waited months without payment. What would you do if you were the judge? More time or enforce the rules?
On her case. So they filed this action to terminate your tenancy. Now, they filed the action back in November. They've been trying to get you to move since November the 19th. It's now February. So we adjourned the matter 1 week because you were in the hospital last week. So we continued the matter until today. The law says you are entitled to one week adjournment, which would adjourn the matter till next Friday, the 13th. Then you would get 10 days from that day to move out, or you would be subject to being evicted. That would be February 23rd. Have you made any arrangements to find a place to go?
I've already got a place, Your Honor, but I can't get my stuff or my animals off the property because of all the snow and the ice. I'm already living somewhere else. I just come to the property to take care of my animals.
Judge, may I offer an observation?
Yes.
Thank you. It is my understanding that Richard has already personally moved out to Dan Trans a few doors down the road. That, if so, that's a good thing. And the other thing is, we would be willing to give him 30 days from today to retrieve or remove his personal property.
You're supposed to be my family friend, Jay. You were friends with my dad. You were at my dad's funeral.
All right, well, Richard, this is a situation where it is what it is. Can you move out within 30 days?
Yeah, I'm trying to find a place for my animals right now.
What kind of animals are we talking about?
I have domestic foxes. I've had them 9 years. I've got domestic foxes. I've had them 9 years. I have not moved out of the property. I'm living somewhere else, but all my stuff is still on the property.
How many fleet foxes are there?
There's 3.
I'm not sure if it's
They're
legal.
domesticated. The DNR knows I've had them. I've had them 9 years. It's the only thing I have left.
Any other animals?
Dead. Apparently, I don't have any friends no more.
All right, well.
I apologize, Judge Middleton. I'm extremely upset.
You don't need to apologize. This is
I'm still dealing with
stuff.
my dad's death. He was my best friend, and I got Jay Felt on top of me now. I'm sorry, Jay, but this is bad.
Yeah, it is.
You don't know how much I miss my father.
All right, what was your dad's name?
Gerald DeWitt.
I don't know that I knew him.
He died November 3rd, unexpectedly. And he's the one that bought the building out there and put me in that building because my other building burnt down. So he bought me that modular home and put me in that modular home with no heat or electricity. My first building burnt in a fire. They collected the insurance check, and he bought that modular building for me to stay in, so I'd have a place to stay.
Well,
and he died,
obviously,
and then he died 6 months later.
Well, let me ask this, Mr. DeWitt. Are you willing to move out within 30 days?
Yes,
30
sir.
days from
Yes,
today?
sir. Yes, sir.
That'll be March 6th.
My dad's dead. My dad's gone. There's nothing else for me there.
All right.
But I don't want anybody to hurt my animals or take any of my stuff because I need time to get the snow off the ground so I go back there and get it.
All right, 30 days from today is March 6th. As a practical matter, no writ of eviction would enter until Monday, the 9th at the earliest. You would have 10 days to appeal this until February 16th, 26. Mr. DeWitt, you've indicated that you moved out, you've got your property out of there. They're just some animals. Maybe hard to
the building's full. I've got all my stuff in the building. I've got both of my boats there, my animals, everything's still there.
Well, they don't have to evict you on March 6th. They have 30 days from today. But the point of fact is, once your father passed, the property becomes the property of his wife, who's your stepmother. You're a tenant at sufferance, and they want you to move. apparently you found a place to move to. They just want to get your stuff out of there. Now, you just consented. You do have 5 business days to tell the court if you change your mind or you misunderstood what we just did. But you just agreed to move by March 6th, or you'd be subject to being evicted, where the sheriff puts all the stuff out, and that's not good. So do you
What would you
understand
advise me
that?
to do?
Yes, sir. Say that again.
Could I get till April 1st, Your Honor?
Mr. Felt?
Could I get till April 1st because I have boats and I have
yeah, I
a lot
heard
of
you.
acres of stuff there?
Judge, I think 30 days is more than adequate. He had the whole month of November, December, January to do something and didn't.
Yeah, this is, it would go past the 23rd by 13 days. All right, they're not willing to go to the 1st, but they are willing to go 30 days, which is more than the 10 statutory days. So is that acceptable to you, Mr. DeWitt?
Sure, yeah, that's fine.
All right, I just wish it weren't so. Why don't you go out to the counter and the clerk will give you a copy of this. All right, Mr. Schluck, you know how to get a hold of Mr. Felt if you need to ask him questions. All right, that's a tough spot. Mr. Felt, you're good to go. We're awaiting a consultation in the breakout room. And
thank you, Judge.
In fact, last Friday stinked, and so did Wednesday night. They didn't look too good against Minnesota either, so I hold you responsible for that.
Judge, I'm afraid they're losing their mojo.
Yes, I think so.
Dear.
Let's hope and get some back. All right, thanks.
Thank you. Have a good weekend.
All right, as soon as I finish this last case, I'm about to depart for Chicago. So hopefully Meg can join us here briefly. I started my day at 20 after 8, went till 1 minute to 1, and turned on again at 10 minutes after 1. So I'm shaped like a shrimp. I've been sitting in this chair for 6 hours.
Well, and you get to sit in a car, train all the way to Chicago.
Yeah,
So.
and I get to sit in a car, drive down the Dan Ryan Freeway. Actually, we'll probably take Lakeshore Drive. Friday night is not the best time to drive into Chicago.
There's just not a good time. I've got to go to Minnesota in July, and I'm trying to figure out how to plan it so I go through Chicago in the middle of the night.
Well, if you go out far enough to the west, but even that's bad. And so, yes, I just had done that myself in October. Anyway, I go there quite often. And I'm just a St. Joe County driver, not a Chicago driver.
Is it not worth it for you to take the train from, I don't know what's closest, Dowagiac?
That's from Kalamazoo. My son takes it all the time. In fact, he took it home. No, we've got luggage and presents and that kind of stuff. Okay. And I'm not sure what defense the defendant is discussing with Meg, but it seems pretty straightforward. Ms. Smith, when was rent last paid?
I'm not sure. I'm not.
I can tell you, Your Honor. We discussed last week that there was that $2,186 judgment entered in October of last year. Ms. Ellsworth indicated she did make that $2,000 payment, and that's the $186 carryover, and no payments have been made since then.
All right. No payment since then. So, okay. November, December, January, February. Well, while we're waiting, this is a second hearing.
I did send all of the information down late Friday morning after our hearing, to Meg. So she should have everything that I'm looking at in her email. I don't think she probably has had a chance to look at it since I sent it last Friday.
Page one of this, I think I attached it to something else, so. Elaine, I think I attached the first page of my notes in Three Rivers Village versus Ellsworth to one of the earlier files. So let's try to recover that and put it back with a file it goes with. Oh. I just learned that Judge Donald Sanderson from Hillsdale passed away, retired. He was a very good judge, very good mentor for me.
This is where the case shifts from numbers to humanity. The defendant reveals his father passed away unexpectedly. He's grieving. He says he's been staying in a modular building with no heat. And then 3 domesticated foxes enter the picture. Emotionally, it's heavy. Legally, it's complicated. The court has to separate sympathy from statutory requirements. The stepmother now owns the property. There's no formal tenancy agreement in place. And local township rules don't allow living in an unheated structure. The judge offers 30 days, more than the statutory minimum, which is actually a significant extension under landlord-tenant law. The question becomes, is this compassion within the law or the last possible chance?
Now,
Do you
Judge
still need
Middleton,
spaces?
Brianna did call me last night and asked me for
Just
an
a
account
minute.
number
Okay,
to go pay her rent at Walmart, but I still haven't received one. She said she
did you
was waiting
find
on
that
full money.
page attached to one of these other things?
What are you looking for?
The first page of my notes in Three Rivers Village versus Ellsworth.
Okay.
Let me see if they're over here. No. And they're not here. So I think it got mixed up with something else. All right, the parties are back. We're on hold here. All right, while the parties were in the breakout room, I inquired of Pamela Smith and Sarah Reed when last payment was made by the defendant. Their representation was the same as last time. The no payment's been made since October of 2025. The claim now is that rent through February with late fees, utilities, and pet fees is $2,772.41. court costs of $180 for a total of $2,952.88. Ms. Reed, do you agree with that?
Your Honor, there was just that we discussed it last week, and Ms. Ellsworth agreed that judgment from October there was $2,186, and she paid $2,000. So that $186.66 was kind of what we started out with our beginning balance.
But was that included in the 512, or do I need to add? I lost the last week's note page.
Yeah, no, it wasn't, Your Honor. That was just the straight rent from.
Right, so do I need to redo this again and add?
Yeah, well, I did it for you while we were waiting.
186.66.
Yes, that plus the 2772 should be 2959.07.
All right, 22,772.41 plus the unpaid balance of the agreement was 186.66.
Correct.
Which equals, give me that number again.
Sure, 2959.07.
If we add 180.48 to that. You get 3,139.55. Is that what you got?
Yes.
Ms. Bauer, what's and I know you don't represent her. You just consulted with her. Is there anything you wish to add?
Yeah, thank you, Judge. So first, I'll indicate that Attorney Reed
I found it.
Oh, I just printed another one.
All right, thank you.
You're welcome.
Attorney Reed did preemptively send me some documents last week, so I was keeping an eye open for some contact from the defendants. I hadn't seen any. I double checked again today. At the end of our conversation in the breakout here, I asked them what number they called and when they called, and it turns out I looked at my my call records, and I received a 2-second voicemail from a number that was unknown at about the time that they represented that they called. So for some reason, their message didn't save. So they did attempt to contact me right after court last week, it appears. I usually send people to our intake line for that reason. But that said, in conversation with the defendants, we were able to get to the bottom of a number of the issues, but I did identify 2 points of concern. One, I'm not certain that there's a lease between the plaintiff and the defendants. And I noticed that there appears to be there appears to be a fixed water charge and an unfixed water charge, and a fixed sewer charge and an unfixed sewer charge. And the basis for those charges is questionable or unclear to me. So I think there's a triable issue of fact there. So I would ask the court, based on the fact that there's a pending application for assistance with Neighborhoods, Inc., based on the fact that they do appear to have attempted to contact legal aid for assistance, and based on the fact that I can't proceed any further than I have just done without ensuring their eligibility for our services, completing an intake and a retainer agreement, that the court consider adjourning the matter pursuant to the court rule that authorizes pending applications to be adjourned. Give them a chance.
Ms. Ellsworth, let me ask you some questions. They contend you haven't paid any rent since October. So what's your plan?
I'm going to be honest, 100% honesty. I am actually currently waiting for my school money. That is how I planned on getting everything caught up, including a rearage of $1,300 that I made an agreement of $100, which wasn't from when we were living there, but I got to do what I got to do. So I'm just waiting for that. I just started work last week, so that's going to help big time as well.
I'm not a big fan. This happens a lot of people using their educational loan money to pay rent or rearages. They never end up getting a degree. They've got a bunch of unpaid student debt, which is not dischargeable, and they're gaming the system to use financial aid money to pay rent. Do you expect a tax refund?
Yes, I'm waiting for that as well. Whichever one's coming first. I'm supposed to get it on the 13th. That's all I'm waiting for.
All right, I'm not inclined to adjourn this. We gave you the number last week. You made one feeble attempt to call. You haven't actually filed anything that shows you filed with Neighborhood Inc. If they do give you assistance, immediately share that with your landlord. You were considerably behind in your rent in October. They worked out a plea agreement or a settlement agreement to try to allow you to stay there. And you paid them back by leaving an arrearage and then not paying 1 penny of rent ever since. There may be issues with the water. There is as I said, this particular complex has got very high water bills, but I'm going to use the number provided. I'm going to ask for a judgment. Now, Ms. Ellsworth, you can do two things with this. You can share with Neighborhood Inc. Say, this is how much they say I owe, $2,952.88 through February. Or DHS or other agency. You can stay in contact with your manager and let her know what your intentions are. But you have to pay the entire amount. Let's say Neighborhood Inc. gives you $2,000. You still owe an additional $952. And then on March 1st, you would owe March's rent. But obviously you want to keep your tenancy, but it's been a real rocky road since last summer. And no rent has been paid in 4 months, as in zero. So they can agree to work with you for up to 56 days from today's date. And then they actually have another 56 days before they actually serve the writ. The problem is they have a waiting list of people that would like to rent your apartment. And they may just not want to dink around with this anymore. You either pay the rent or don't. Now, Ms. Bauer contends there may not even be an existing lease. Let's see what I've got, which makes your situation even more tenuous.
Yeah. When we had court back in October, that's when I filled out the application and that, and I'm still waiting for a lease to sign.
I would contend that draws into question their ability to collect anything other than lot rent.
Yeah, that's a good point. If there's no lease, they may not be entitled to anything else. Let's take a look.
Not even my correct address on the court
They
papers.
first filed this in November, the demand for possession, and then nothing's been paid since.
I have not received anything like that, but also I received none of my court papers. They're all to the wrong address. It's the correct lot number, but not the correct address. It's to 520 13th Street, lot 71, and that is not where I live.
Where do you live?
1302 Linden Drive, lot 71.
I just addressed that today, Judge Middleton, with Bonnie, and we are trying to get that corrected.
Well, this is all screwed up. What they're evicting is your trailer. Not you. This is another one of lot rent only. I'm not a fan of these. So
yeah, it's not even my trailer.
Yes. Well, if you don't have a lease, this is a mess. And Ms. Reed, you inherited this mess. This has been a mess growing for a while. They've had several different owners, and all the old trailer home parks have been bought by large companies, and there's sewer problems and aging infrastructure problems and no lease problems. She's right. You don't have a lease. I don't know how you ask for utilities. I don't know how you ask for anything other than lot rent. So there are a couple options. I am going to grant Ms. Bauer's request to adjourn this. Who owns the trailer?
My cousin Ashley Rosner.
Yeah, you told me that. Well, she has a stake in this because what they're asking me to do is evict your trailer off that lot. They can do it the correct way, which is file a just cause termination for 3 late rents in a 12-month period, in which case you would have 10 days to move out or 90 days to move or sell the mobile home. But this is an eviction of the lot. Many Michigan judges don't allow it. Judge in Livingston County wrote a very learned opinion about why this is not allowable under the law. Other judges do allow it. I allow it because it lets the defendant try to redeem the lot. If it was a just cause termination, Neighborhood Inc. couldn't give you any money. So anyway, but there you are. No one's paying the rent. You're not paying it. Your cousin's not paying it. It's just sitting there. And so they're asking to evict the trailer. We don't have a lease. So we're going to have to recalculate all of these numbers. Yeah.
I will say, Judge, that Attorney Reed and I have a history of working well together, and I have a couple of ideas on how this could get resolved as long as Ms. Ellsworth is eligible for our services.
Well, let's look at where to put it. Miss Ellsworth, you haven't exactly been proactive on this. You just didn't pay. They gave you a notice to quit in November. You let the clock tick. You didn't pay anything.
I didn't get a notice to quit in November because they had the wrong address.
One half-hearted attempt to contact legal aid. Next Friday is the 13th. The 16th is a court holiday for President's Day, and then I have an important appointment on Duval Street. No, boy. I've got a couple of cases with Meg, Golden Pond Estates, on February 27th that they're fun too. How about if we continue this? Ms. Reed, does this work for you if we continue it to Friday, February 27th at 10:45?
Yeah, I'm sure that will be fine.
All right, February 27th, 2026 at 10:45. All right, we'll try to figure this out. It's in everybody's interest to maintain this tenancy. The park really doesn't want to tear this trailer off this lot. In fact, it probably can't even be moved. And it's expensive. It costs several $1,000s to take the trailer off the lot. And then there's a question about where do you move it to? It's not just this company. All the parks here in St. Joe County are using this method. Maybe I'll just stop allowing it and make them go back to just cause terminations. But this does allow you to get some emergency assistance. So we got to figure this out. There's no lease, so we got to recalculate the numbers. But you can't just stay there indefinitely without paying any rent at all.
I planned on
And,
paying, I tried to pay February's payment the other day, but I was given the wrong account number to do it through Walmart. So Pam did get with me yesterday, and unfortunately I was at work.
All
so I
right, well,
didn't
go
get
ahead
to
and
make
any
it.
payment you make will be applied to the arrearage.
Okay.
All right, we'll take another crack at this. Essentially, everything we just did was hollow. Told my wife I'd be home by 3 o'clock, but I don't think I'm gonna make it. All right, let's figure out where we are. Any payments you make will be applied to any shortfall.
What we witnessed today wasn't just eviction math. It was a complexity of housing law colliding with real-life hardship. In one case, tenants fell months behind and relied on pending assistance that hadn't materialized. In another, a mobile home park eviction revealed missing leases, disputed utility charges, and service address errors. And in the final emotional case, a grieving son agreed to vacate property after his father's passing, with the court granting 30 days to remove animals and belongings. Judge Middleton enforced statutory rules, but also exercised discretion where permitted. The broader takeaway? Landlord-tenant law is procedural, time-sensitive, and unforgiving when payments stop. But courts still try to create structured paths forward when possible. If you found this case as complex and eye-opening as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more in-depth courtroom breakdowns just like this one.
You guys are gonna figure this all out, and when I see you on the 27th, you'll have a good solution for me.
Absolutely.
All right, thank you. We
right.
got a new batch on Monday. Sarah, thank you for your help.
Thank you. Have a good weekend in Chicago.
All right, thank you. Okay, thank you. I'm gonna stop the live feed, try to repackage and ready to go home.
Thank you, Judge. That's the last case then.